You know, when we think about the First Amendment, we tend to picture this absolute, unbreakable shield for free speech. But honestly, that's not the whole story. The reality is, well, it's a lot more like a scale. It's this constant, delicate balancing act between our freedom to speak our minds and the needs of a society that actually works. So today, let's break down that balancing act.
I want you to imagine this for a second. You're at the funeral of a loved one, a soldier who died serving their country, and right outside you see signs with messages just like this one. And look, this isn't some made-up scenario. This was the real-world tactic of the Westboro Baptist Church, led by a man named Fred Phelps.
And this gets us to the central, really gut-wrenching question, doesn't it? When does one person's right to say something incredibly hateful collide with another person's right to just grieve in peace? Is this protected free speech? The answer, as we're about to see, really pulls back the curtain on the hidden limits of our most cherished freedom.
So, if you actually read the text of the First Amendment, it's famously simple. But from the very beginning, the courts have known that it just can't be a total free-for-all. There have to be unspoken limits, these gray areas where speech can cause real, tangible harm that society actually has a right to prevent.
The first big line in the sand came from a case called Schenck v. United States, and it gave us what's known as the clear and present danger test. The classic example you always hear is this one. You can't falsely shout fire in a crowded theater. And why not? Because in that specific moment, your words stop being just words. They become an action that creates immediate physical danger. This was really the first time the courts officially said, hey, context is everything.
And that right there, that's the core tension we're exploring. On one side of the scale, you've got the individual's right to express themselves, no matter how unpopular or even offensive their views are. But on the other side, you have the government's job of maintaining order, keeping people safe, and protecting its citizens from specific kinds of harm. The entire story of the First Amendment is the story of this exact balancing act.
So how does this balance actually work in the real world? Well, let's start with this idea of a captive audience. The law recognizes that sometimes an audience can't just turn around and walk away, which makes them uniquely vulnerable to speech that is specifically designed to hurt them.
Which brings us right back to those funeral protests. The speakers here, they aren't just talking to the general public on a street corner. They are specifically targeting grieving families. They're using a moment of profound vulnerability as a stage for their own message. So the law has to ask, does that change the whole equation?
For a long time now, courts have recognized the unique trauma of losing someone you love. This quote from an old court case isn't just poetic, it's the law, basically acknowledging that people who are mourning are in a state of heightened vulnerability. They are, in a very real way, a captive audience to their own grief, which makes targeted verbal attacks uniquely damaging. And it all comes down to context, which this slide lays out perfectly. If you're protesting in a public park, people can choose to listen to you, or they can just walk away. No big deal. But at a funeral, the audience is captive. They're there for one solemn reason, and the protest is aimed right at them. And that's the moment when public speech can cross a line into personal harassment.
And this isn't a one-off idea. The courts have drawn this line in a lot of other places too. They've upheld buffer zones around medical clinics to protect vulnerable patients. They've shielded hospital patients from super disruptive protests. And they consistently uphold laws against telephone harassment. In every single one of these cases, the principle is the same. The First Amendment doesn't give you the right to target and torment someone who's captive or uniquely vulnerable.
Okay, so let's zoom out a little bit, from the individual to the crowd. What happens when a protest itself, even a totally peaceful one, starts to clash with the public's right to just use public space? This is all about regulating the public soapbox.
A perfect modern example of this is the Occupy Wall Street movement. Protesters set up this long-term camp in Zuccotti Park, which is a privately owned public space in New York. This created a classic First Amendment problem. You had the protesters' right to assemble, clashing with the city's need to manage a public area. Now, when the city eventually cleared the park, the really key thing was their reasoning. It wasn't about the content of the protest. They weren't saying, "We don't like your message." It was about practical things like blocking public access, major health and sanitation concerns from overflowing trash, and public safety issues. These are exactly the kinds of societal needs that get weighed on the scale against the right to protest. So how do courts decide if a regulation is fair? Well, they use this, the time, place, and manner test. Think of it like a 4-part checklist. First, the rule has to be content neutral, meaning it can't target a specific message. Second, it has to serve a real government interest, like public safety. Third, it's got to be narrowly drawn. You can't use a sledgehammer to solve a problem that needs a scalpel. And fourth, it has to leave other ways for the speakers to get their message out. You can regulate the protest, but you can't silence it completely.
All right, let's shift gears and talk about another huge part of the First Amendment, freedom of the press. We often call the press the fourth estate because of its crucial watchdog role in our democracy. But even this incredible freedom isn't absolute. It too gets balanced against other vital things, like national security and a person's reputation.
The most severe limit you can put on the press is something called prior restraint, which is just a fancy legal term for government censorship. Now, the key thing to understand here is that the courts have a heavy presumption against it. What that means, thanks to huge cases like the Pentagon Papers, is that any attempt by the government to stop a story before it gets published is almost certainly going to be struck down. The government has to climb a mountain to justify it. This level of protection didn't just appear out of nowhere. You can see on this timeline how it was built up piece by piece. Starting back in 1931, the court started building a wall against prior restraint. Then, in 1964, a case called Sullivan made it incredibly hard for public officials to sue for libel. And finally, in 1971, the Pentagon Papers case cemented that wall, even when it came to national security.
And this brings us to the actual malice standard, which was a total game changer. For a public figure to win a libel case, it's not enough to just prove a story about them was false. They have to prove the journalist knew it was false or acted with a reckless disregard for the truth. This is what protects the press from being sued into silence just for making an honest mistake while investigating powerful people.
And here you can really see the heart of the balance in press freedom. The law gives journalists a ton of breathing room to investigate and report, which we absolutely need for a healthy public debate. But it's not a blank check. That actual malice standard is the line in the sand. It makes sure there's still a path to hold people accountable for deliberately false and harmful reporting.
So where does all this leave us today? All of these balancing acts, which were developed over 100 years of court cases, are now being tested on this brand new chaotic battlefield, the internet. And the old rules are really struggling to keep up with our new digital reality.
Just look at these challenges. When a few giant corporations own most of the media, are we losing diverse points of view? When a blogger like Matt Drudge breaks a massive story, do they get the same protections and have the same responsibilities as a traditional journalist? And in this age of viral disinformation, how in the world do we draw a line between protected, even if it's false speech, and actively harmful lies? These are the tough questions courts are grappling with right now.
Through all these complexities, the one guiding principle has always been this: the marketplace of ideas. It's the belief that the best way to find the truth is to let all ideas, good and bad, compete out in the open, in the public square. The assumption has always been that, over time, the truth will win out.
But that brings us to our final and maybe most critical question. Today, our public square is often governed by algorithms that are designed to feed us what we already believe, trapping us in these digital echo chambers. So in this new world, are ideas truly competing on a level playing field? Or is the marketplace broken? The First Amendment's Great Balancing Act continues, and its next chapter is being written as we speak.